Hi, everyone. You know, in district, people ask me a lot of the times exactly what are we doing up there and what happens when we're debating a bill on the floor. So I thought you might like to see what actually happens when I'm on the floor bringing out a bill that is controversial. This particular bill is an act concerning guardianship appointments for individuals seeking special juvenile immigration status. Now, I know that sounds a little scary when you first hear it. We're talking about immigration, right? Well, these are children that have managed to find their way into our country because they've been abandoned, abused, and neglected. So they might have come in with a parent who then left them or abused them, or they might have come from a country where there was war and poverty, where they were being forced into gangs. So they have ended up here, and there is a federal program to allow them special status so that they can pursue staying in our country. What this bill was about is in Connecticut, we end that at 18, and the federal government ends it at 21. So the courts were saying to us, you know, Connecticut, you need to think about that gap between 18 and 21. The federal government says 21. So we introduced a bill to say, you are still a youth between the ages of 18 and 21. You still are under the protection, are dependent. There are very specific criteria that the child has to meet. And once you've met that criteria, you can apply for the federal standard. We in the state of Connecticut don't set that standard. We merely say you have met the criteria. So please take a look at this debate. I think you'll be very interested. And at the end of the debate, there is an amendment that's offered, which I have not put up, but it is an extraordinary extension of the debate on federal immigration policy. And if you're interested, you simply go to CTN and look at the session on April 18th. So I'm really hoping that you enjoy this look at how it actually works up in Hartford.
If I may, a couple of questions to the proponent of the bill.
Please proceed.
Thank you, Mr. Speaker. I had voted against this bill in the Judiciary Committee when we saw it, and frankly, I think in part it was trying to get a better understanding of what the bill does. And I guess this bill distinguishes between juveniles in general, and it specifically relates to individuals with immigration status, some sort of immigration status, or does it apply to all juveniles between the ages of 18 and 21 through you?
Representative Urban.
Through you, Mr. Speaker, no. This is very specific, and it reflects federal law that has been in place for 28 years. The federal law goes to age 21 because of a definition that we have in our state. We don't go to 21, we go 18. So this is to fill that gap, 18 to 21. They have to meet specific requirements before the probate court will allow them to have the special finding, which then allows them to go on to the federal government and apply for this status. Through you, Mr. Speaker.
Representative Candelora.
Thank you, Mr. Speaker, and I do recognize that there's some hurdles to jump through. Under current law, these individuals that would fit the criteria that might be 19 or 20 years old, what happens right now without this law being in place through you?
Representative Urban.
Through you, Mr. Speaker, my assumption is that they would be being looked for and deported. Through you, Mr. Speaker.
Representative Candelora.
Thank you, Mr. Speaker. So what this does is sort of enables somebody to step into their shoes and represent them for that time in order to stay here for guardianship purposes through you?
Representative Urban.
Through you, Mr. Speaker, that is one of the requirements, so that person that is applying for this, first of all, cannot be married, and they have to consent to the guardianship of an individual that we've found that can offer that guardianship. Through you, Mr. Speaker.
Representative Candelora.
Thank you, Mr. Speaker. And one final question. As I read it, it's not all individuals who may be immigrants. These are particular individuals. So under what circumstance, if I could get just one example of somebody who might fit into this criteria through you?
Representative Urban.
Through you, Mr. Speaker, we had an enormous amount of testimony, and all the testimony was in favor of the bill. These are children who have ended up in our country abandoned, neglected, or abused. How they've gotten across the border sometimes might be with parents who then abandoned them, or they have fled from situations in their own country where they were subject to war, death, whatever. They have been abandoned, they've been neglected. We had several children come in and speak to us, but I would refer the good representative to the actual Supreme Court case, which was Henry, and I don't have the number, but I can refer you to that case, which would then show you exactly why the Supreme Court asked us as a legislature to move forward and close this gap. Through you, Mr. Speaker.
Representative Candelora.
Thank you, Mr. Speaker. I don't have any further questions. I appreciate the clarification.
Thank you. Representative Dubitsky of the 47th. You have the floor, sir.
Thank you, Mr. Speaker. A few questions for the proponent, if I may.
Please proceed.
Thank you. The good representative had indicated that there are other states that have already done this. Through you, Mr. Speaker, I would ask, what other states are they?
Representative Urban.
Through you, Mr. Speaker, there are a significant number of states who define minor up to age 21, but there are ones that don't, and we are one of the ones that don't. Of the ones that don't, New York, California, Maryland, New Jersey, and Massachusetts have made this adjustment. Through you, Mr. Speaker.
Representative Dubitsky.
Thank you, Mr. Speaker. And I would ask that on those few states, and I would just note that we seem to be grouped into sort of a category with those very states in a number of things, some of which are not necessarily beneficial to our state. But I would ask, in those states, what is their current age of majority for other things, such as the age of majority for becoming emancipated from your parents? In my understanding is 18 in Connecticut. So through you, Mr. Speaker, I would ask, what are the ages of majority in those states that we are going to be emulating?
Representative Urban.
Through you, Mr. Speaker, I believe that the age of majority is what it is in Connecticut, which is 18.
Representative Dubitsky.
Thank you. And through you, Mr. Speaker, am I correct in interpreting this to say that should this bill pass, we will be extending that beyond the age of majority, so we will then be considering juveniles to be up to 21? Through you.
Representative Urban.
Through you, Mr. Speaker, only under these special circumstances, which are being overseen by our probate court, and within that special circumstance, if the probate court deems that these children are in fact meeting the criteria, then they would be able to apply to the federal government, because it is the federal government that has established the age of 21, not the state of Connecticut. We are simply trying to close that gap. Through you, Mr. Speaker.
Representative Dubitsky.
Thank you, Mr. Speaker. So am I correct to interpret the good representative's answer to mean that the federal government considers a person a juvenile up until the age of 21? Through you.
Representative Urban.
Through you, Mr. Speaker, as applies to special immigrant juvenile status under the U.S. Citizenship and Immigration Services, the federal government does use the age of 21 under those circumstances. Through you, Mr. Speaker.
Representative Dubitsky.
Thank you, Mr. Speaker. Are there any other aspects of our law that would be affected? And what I mean by that is extending the term juvenile to a person that's 21 years old in this particular circumstance. Would that affect any other circumstance of our law that would reflect on the age of majority of an individual? Through you.
Representative Urban.
Through you, Mr. Speaker, we've worked very closely with the probate court to be sure that this would not have unintended consequences any place in our state law, that it is specific to what the federal government and the Connecticut Supreme Court has asked us. Well, the federal government didn't ask us, that's their policy. But the Connecticut Supreme Court directed the legislature to try to close this gap. Through you, Mr. Speaker.
Representative Dubitsky.
Thank you, Mr. Speaker. And so, for example, if there are provisions of our law that treat individuals as adults for the purposes of criminal penalties, if the probate court found that a given individual was a juvenile for the purpose and they were up to 21 years old, would that have any effect on any type of criminal penalties that might be imposed on this person who was now deemed still a juvenile at the age of 21? Through you.
Representative Urban.
Through you, Mr. Speaker, absolutely not. This only impacts the federal policy.
Representative Dubitsky.
Right. And with regard to the amendments, I heard the discussion that these were just essentially technical. Can I, with regard to, was the definition of minor child incorrect in the original bill? Is that why it needed to be fixed? Through you.
Representative Urban.
Through you, Mr. Speaker, it is my understanding that it was not, in fact, incorrect. It was just that our LCO and the probate court had language that they felt more comfortable with in coming into compliance with federal law. Through you, Mr. Speaker.
Representative Dubitsky.
Okay. Thank you, Mr. Speaker. I appreciate it.
Thank you, sir. Representative O'Neill of the 69th District. You have the floor, sir.
Yes, thank you, Mr. Speaker. If I may, a couple of questions. The proponent of the bill earlier on alluded to a court case that apparently is involved in the basis of this legislation coming forward. And so I was trying to find that court case, and unfortunately, in the time that we've been having our discussion, I wasn't able to. So I believe, in looking at the materials that are attached to the bill, the LCO, or rather OLR report, there's reference to a case of Henry B. And I'm wondering, is that the case in Connecticut? Was it the Henry B. case that was what caused the Supreme Court in Connecticut to suggest that we change the statute? Through you, Mr. Speaker.
Yeah.
Representative Urban.
Through you, Mr. Speaker, yes.
Representative O'Neill.
And was that case a Connecticut case, or is Henry B. a federal case? Because I did find a reference to a federal case, Henry B., that goes back to 2007. And I'm just, is it by accident that they happen to have the same names? Because the other reference was to a case this past fall. Through you, Mr. Speaker.
Representative Urban.
I'm not familiar with the other case the good representative is referring to, but this was, in fact, a state case, and it was ruled on ultimately by our state Supreme Court. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. And if I could ask, again, because I haven't been able to locate that case myself, if the proponent could sort of explain what the basic underlying facts of that particular case were. Through you, Mr. Speaker.
Representative Urban.
Certainly, Mr. Speaker. Through you. It was Henry P. BP. I do have some numbers that I could give to you. But what happened was, in Henry's case, his mother, who was represented as his guardian and his stepfather, he turned 18 before the case was heard. And so it was denied. And that's why it went to the Supreme Court, and they adjudicated that case in favor of Henry. And it was in that moment that they told us we needed to close that gap from 18 to 21 so that we would be in compliance with federal law. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. But then was the relief that the plaintiff, Henry P., seeking it sounds like it was granted, that the Supreme Court ruled in favor of the complainant or the petitioner. Is that correct? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, yes, that's correct.
Representative O'Neill.
Then that leaves me wondering why is it, if the court was able to grant the petitioner his requested relief, why we need to change the statute? What is it that, if they were able to act on it in his favor, how did they get there if the statute doesn't support the action? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, it was that he turned 18 during the pendency of state court proceedings. And when he turned 18 during it, that led them to, I believe, the lower court to then say he would not get the status that he, or the status to seek federal protection that he was looking for. So he was 18 when they started. They asked for an emergency proceeding. They didn't get there, so that's why it went to the Supreme Court. But it was because he turned 18 at the time. They had applied before that. So that brought the court to say to us, as a legislature, we should come into compliance with federal law. Through you, Mr. Speaker.
Representative O'Neill.
I apologize, Mr. Speaker, but I was having a great deal of difficulty understanding a lot of the answer that was put forward. So let me ask, perhaps I can tease out some of the question that I'm not sure about. Was the action by the Supreme Court insufficient? Was the plaintiff or petitioner unable to get the relief from the federal government because he turned 18 during the pendency of the action, so that he won in Connecticut but lost at the federal level? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, it is a two-step process. So until and unless we have indicated that this particular juvenile has met the requirements that we as the state oversee, the particular individual cannot go to the second step, which is the federal government. So what had happened here was he was in court proceedings, he turned 18, and that's what caused the problem. And the Supreme Court, in reviewing and granting him the granting oversight to go on with a special immigrant juvenile status, indicated that it would be a good thing for our legislature to take positive action on that gap between 18 and 21. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. But just to follow up, do we know whether the individual in this particular case was able to obtain the relief that he was seeking all the way through the federal government, I assume, administrative proceedings? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, I can't say for sure that I absolutely know that. I only know what the court directed us as legislature to do. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. And if I might ask, this sort of a change in the status of our laws relating to probate courts and that sort of thing, especially something that originated from a Supreme Court decision. Ordinarily, I would think of it as something that would have started in the Judiciary Committee. And I'm just wondering why this particular change, which is rather of a technical one, as the amendment which we just passed was very technical and changing the law with respect to this type of jurisdiction. Why did it originate in the Children's Committee instead of the Judiciary Committee? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, we do, in fact, have cognizance over anything that applies to children. And we took this bill in discussion with Judiciary knowing that it would have to go to Judiciary also. So that's why we started it in children. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. So, and try to understand, are there other cases, do we know if there are other cases that are going to be affected by the passage of this particular piece of legislation that are currently pending? Do we know if there are other cases like that that are in our court system? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, I do not have a number. I am only able to assume that when we change that from 18 to 21, that there will be people that will be coming forward to try to be under the special immigration juvenile status and apply for that federal protection. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. And I noticed also there was a reference to that there was a considerable amount of testimony. In the course of the testimony, were there any people who said that their cases would be affected by this? I did take a quick look, and there is quite a bit of testimony. I started reading through it, but I'm just wondering if there are, during the course of the public hearing, whether there were people who testified that they would be affected, their case situation would be affected by the passage of this legislation. Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, the majority testimony that we got from young people were people that had availed themselves of this before the age of 18, and they came to testify to tell us what a difference it made in their lives and what they're going to be able to achieve and their ability to actually be able to be a part of a job and economic growth, et cetera. So that was the testimony that we received. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. And again, one of the things that was mentioned was that there are a number of states that have made changes related to this federal law, which I gather from the earlier conversation has been on the books for about 28 years. So I guess I'm a little surprised that this is the first time that it's coming to our attention. And in a quick look, I noticed that there were several states that made changes. Do we know if this is something that's going to be part of like a national wave, so to speak, or is it just that most other states already have 21 as the age of majority for probate court purposes and that sort of thing? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, I cannot comment on whether it's a national wave. The only thing I can comment on is it's been federal law for 28 years, so I can't anticipate, I can't extrapolate and project what kind of numbers there might be. But I do think it is appropriate for us in the state of Connecticut to be in compliance with what the federal government's law is. Through you, Mr. Speaker.
Representative O'Neill.
Yeah, thank you, Mr. Speaker. The other part of this question about why this is coming up at this particular moment that I'm wondering about is, since it has been on the books for 28 years, was there any testimony that there were people who were denied access, who were told you turned 18 or you're too late because our minimum age or maximum age for juvenile is 18, that you're ineligible? Did anyone testify that they would have sought the relief but weren't able to do so because of our age? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, we were certainly apprised of juveniles where that had happened. But in order for that juvenile to come and testify would be a little difficult because now they had not been awarded the status and they were over the age of 18. So we did find from the people that came to testify that there were indeed juveniles who were not able to do this because of the gap in our law in Connecticut. Through you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. And I thank the good chairman for her answers to the questions.
Thank you, sir. Representative Smith of the 108th.
Good morning, Mr. Speaker.
Good morning. You have the floor, sir.
Thank you, sir. Just a few questions, if I may, through you.
Please proceed.
Thank you. Now, I too voted against this when it came before us in judiciary, mostly because I wasn't sure what it really did at the time. It was one of those referrals and really didn't have the background. It was nice to hear an explanation this morning on what we're really trying to do here. As I understand it, simply raising the age from 18 to 21 to comply with federal law. I think that's the gist of it. The question I do have, though, through you, Mr. Speaker, under the bill analysis, it talks about there's certain criteria that has to be met in order to actually meet the federal standards. I don't know that I've heard that here this morning, what that criteria is for this to actually kick in. So if the chairman could tell me that through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, if I heard the good representative correctly, there are several criteria which the probate court would be the ones that would ascertain whether those criteria have been met. They must be under 21. They must be unmarried. They must be dependent on a competent caregiver. And they must have consented to the appointment of a guardian after turning 18. And they have to have filed the petition with the probate court. And just to remind the chamber, that is the first step in a two-step process. That simply gets them to the federal government. We are not making the decisions. Through you, Mr. Speaker.
Representative Smith.
I thank the chairman for that response. So in order to meet the special immigration juvenile status, the criteria that was just outlined by the chairman, those first have to come into play. Are there additional criterions that have to be met, or is that it? Then it moves from the probate court onto the federal court. Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, in our close working with the probate court, it's my understanding those are the criteria, and it is the responsibility of the probate court, once that petition is filed, to be sure and clear that that juvenile meets those criteria. Through you, Mr. Speaker.
Representative Smith.
Thank you, Mr. Speaker. That's all the questions I have.
Thank you, sir. Representative Belcito of the 53rd District, you have the floor, sir.
Thank you very much, Mr. Speaker. I have a few basic questions for the proponent of the bill.
Please proceed, sir.
Thank you. Through you, Mr. Speaker. Are there any specific reasons as to why the age was changed between 18 and 21? I mean, very specific. Through you, Mr. Speaker.
Please proceed, sir.
Thank you. Thank you, Mr. Speaker. Through you, Mr. Speaker. This was initially offered by the federal government. So it was the federal government under the U.S. Citizenship and Immigration Services that established that age of 21. We didn't establish it. They established it 28 years ago. Through you, Mr. Speaker.
Representative Belcito.
Thank you, Mr. Speaker. In your knowledge of this bill and what is going on, have there been problems with individuals from 18 through 21? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, we had testimony from people that had achieved this status who are under 18, indicating to us that there were people between the ages of 18 and 21 that had not been able to do it because of that gap. But we are not, we were not able to have them testify for obvious reasons because they were between 18 and 21 and did not have the ability to apply for this. Through you, Mr. Speaker.
Representative Belcito.
And one more question through you, Mr. Speaker, to the proponent of the bill. To the proponent. Will this, the change in age here in Connecticut, since it's been in force for 28 years or so, will this decrease the amount of problems we have had in this area? Through you, Mr. Speaker.
Representative Urban.
Through you, Mr. Speaker, I can't speak to whether it would decrease it, but I can speak to the issue of these immigrant children who have been abandoned, abused, and neglected, and would be able now, between the ages of 18 to 21, under the aegis of our probate court and the federal government, to continue their education, to be able to become a productive part of society. So it would be my projection that it would in fact benefit the economy in the state of Connecticut.